convincing after the questions which have been, raised shortly by Francesco regarding what is autonomy, or what is non-territorial autonomy. The phenomenon in focus of the presentation and of the chapter, which is included in the book Tove just has shown you, is the Roma norm. Sorry, before I get into the details, I just would like to apologize for the fact that slides will follow which are impolitely overloaded by characters. Now, I don't expect you to follow all these. I'm going to make a very brief summary of where I think that the interesting and important things are. It is just, I would just like to raise your interest for the things I'm talking about. So I'm highlighting the details which are included in the chapter. Of course, I would be happy if you could read the chapter, but if not, at least this presentation in details, which is a rather detailed, structured abstract of a chapter which is more, so to say. Okay, so this being said, the focus, the phenomenon that chapter deals with is the Roma normative order, which is a phenomenon which is present to date. We don't know exactly when it started, but present to date in strikingly similar patterns in very different areas of the world. You see there, East and Central Europe is the basis, that is where it is most clearly identifiable, but it is also present in South and West Europe, in North America, Central Asia, and Transcaucasus as well. The phenomenon has been in the attention of ethnographic and legal studies researchers so far. It has been described in luxury of details based on ethnographic field research and observatory, participatory observation. And also there is an area of legal studies which has identified the lawmaking mechanisms which have been identified in certain Roma communities and their role in insulating the Roma communities from their environment. Although there is a book, very important book, Weyrauch and Bell, which has a title of Roma Autonomous Law, no attempt has been made so far as I know, to explain or to investigate the phenomenon as a particular form of NTA. Now, the aim of our chapter is exactly that. Yes, we would like to suggest that the phenomenon could be also read or could be also interpreted as a particular form of NTA. It is an eloquent example of customary community-specific normative system, which is coexisting in a surprisingly efficient way with official state law. Yes? Although it has absolutely no legal and official recognition. In some cases, it is a kind of tacit recognition by local authorities. There is even a kind of division of labor that the state authorities allow them to do the work because their job is eased, but no official recognition exists ever, or in no case, as far as we know. But in spite of that, it is very efficient. So the suggestion is that if this case could be accepted as a special form of NTA, then shortages of mainstream NTA theory can be identified, and perhaps based on this example, and considering further examples which exist out there in the world, there are many, many similar examples of community councils or tribal councils and forms of legal pluralism in Latin America, in the Arab world, and of course in the indigenous communities, then perhaps the horizons of NTI theory could be enlarged. Okay, now the paper focuses on one crucial institutional aspect of the phenomenon, which is the Roma court, the so-called CRIS. Yes? And the methodology of the research is so it is trying to, we are going to do a very, or we have done in the chapter, a very detailed literature review, and we have done field work in Romania, and we have tried to corroborate these two things and to see what is what can be found in the reality of Roma communities in Romania today from what is available in the literature. Okay, now the structure of what follows, I'm going to summarize very briefly the main findings of the literature review, and then I'm going to speak about the fieldwork, some findings of the fieldwork, and finally I'm going to try to answer the research question regarding why I believe that the case presented or discussed could be considered as a particular form of NTA. Now, this is just a quick, I don't want to go into the details because these details are very contested. It is not very accepted that we can take for granted what it exists there. But what is interesting, what I'm going to talk about mainly is that it is an early 15th century where we can locate documents which can explain in a way or other the origin of the Roma special status. So I think that there are three waves of migration of the Roma. The main one in black, and the red one in the late 18th century, 19th century, and with the blue one with the early 19th century. Again, many things are contestable. I don't want to go into the details. Now, regarding the origins of the Roma, there is one proposal, again, which cannot be taken for granted, but I think it is interesting to consider, that the special status of the Roma may originate in the so-called safe conducts or recommendation letters, which are to be found in some chronicles in the early 15th century. One which was issued in 1417 by Sigismund of Luxembourg. He was Prince Elector in Brandenburg and also Holy Roman Empire for 4 years. He issued such a letter of recommendation in 1417, which is referred to several times, and it is mentioned by many chronicles. I would like to highlight this quote. So Sigismund makes a recommendation to the authorities of his dominion, saying, the quotes are highlighted, that our faithful Ladislaus, voivode of the gypsies, and others pertaining to him, have the liberty to be supported and sustained without hindrance or trouble, and preserved from any impediments or vexations. And the most important part of the quote is, if, however, any trouble or disorder should occur among them, from whomever it may arise, then neither you, the authorities, nor any other of you, but the same voivode Ladislaus should have the power of judging and acquitting them. Yes? So this is, I think, an interesting quote from which many things may come. Now, there are several similar safe conducts issued or mentioned in the chronicles. You see in Italy, in Poland and Lithuania, Scotland, and also in France. These are all which can be identified. Now, what could be the reason? Why did these rulers issue these letters of recommendation? There are two explanations which I have seen in the literature. One is that the safe conducts were very much self-interested. Yes, so they issued these letters in order to guarantee stability, because with Roma people, disorder and everything was regularly associated, and if somebody was empowered among them to keep them peaceful, then that was a kind of securing stability. Others say that these literas promotorias, the safe conducts, could be the forerunners of passports. Yes? And this is again in a very self-interested. They say that it was meant to assure that these people leave the territory as soon as possible. So it was a means to leave, so make sure that the people leave quickly. And also they were limited in period of availability, so there was a period of time added to the litera which says that is a period to which it refers. Okay, it is very interesting that all these sources also talk about the fact that it is not excluded that the anti-Roma, anti-Gypsy sentiments can be made a connection between anti-Gypsy sentiment, and later on, the anti-Gypsy legislation with this kind of treatment. There is a quote, there are two quotes from two chronicles there. One say that they had a decree of the King of Hungary, who was emperor, by virtue of which they could sieve during the 7 years of their period wherever they might go, and that they could not be subjected to justice. Or another one, with us, sieving and robbing are forbidden on pain of hanging or beheading. For them, gypsies, it is allowed. And so this is an interesting and convincing example that what could be the consequences of this. Okay, now the second thing which I would very shortly highlight is a conceptual framework which is essential in order to understand how this lawmaking system operates. There are 4 concepts which I consider crucial. One is this distinction between Roma and Gajo. Yes? Gajo is everything which is not Roma. Yes, it is including everything except Roma. And the Gajo word is labeled extremely severely by the Roma people. So the Gajo people are considered to be, I have highlighted there something, that they have no sense of justice or decency, and they have no shame or honor, and protect meaningless personal possession, lack flexibility and imagination, being tied to fixed routines. So these are some statements attached to the concept of Gajo. And compared to that, Roma conceive themselves to be guided by honor, and there is a very strict rule of keeping that word separate from the Gajo word, because otherwise it is a contamination which Roma people would like to avoid. And then there are 2 interesting additional things, that stealing from non-Roma is not a problem. It is even maybe a good thing. Yes, and illiteracy. Illiteracy is strategical. Yes, illiteracy is a way how they could keep their word insulated and not penetrated by them. Because I have forgotten to say that all this tradition which I'm going to talk about is oral. Is orally kept, nothing is written. Okay, good. The second concept is Romania. Romania is this ideal concept of what is good, what the Roma need to observe, how they have to behave, what they have to do in order to be according to their concept of what is Roma, what it means to be Roma. It is also a highest authority. It is said in some sources that it is a kind of the Roma Bible, and there is also a comparison made by the Hebrew Torah, and so on and so forth. So it is a very important thing, which again explains a lot from what we are going to find out shortly about the procedures. The marim or marime is the state of defilement. If people are not observing the Romania, then they end up in this state of in this defilement as a marime, and there are 2 ways to get rid of it. They can be banished of the community, or they can be liberated by the proceedings of the Kris. And that is the first thing which we find out, that the Kris, the Roma tribunal, has the very important role to elaborate people for defilement if they have failed to observe and respect Romania. And finally, pakiv is also an important term, which is a cement which keeps the Roma together, and this is a principal concept of honor, which Roma people are not allowed to lose from. Okay. Good. Really?
Okay, but he was shorter in his first presentation.
I apologize. Okay, good. Good. Now, what is a Kris? Is an institution of the main institution of adjudication. Okay. Now, what are the areas of jurisdiction? That's a very interesting thing. There are 4 main areas: material laws, matters of honor, religious or moral matters, actions threatening the integrity of the community. So these are the cases which are adjudicated by the Romani Kris, and of course, okay. Then, procedural aspects, amazingly interesting. So who is the initiator, who are the judges, what are the procedure, how decisions are taken, and how decisions are enforced. Yes. Now, everything is interesting. I cannot go into the details. I would just highlight one important aspect, that the viability and the effectiveness of the whole arrangement is due to the way how decisions are taken. It is taken by the consensus of the whole community. The judges, and especially the chief judge, who is presiding and leading the whole discussion, consider the procedure ended when there is a consensus shared by everybody, including the person who has to defend himself or herself. Yes, and the fact that the community reaches this consensus is the instrument and the guarantee that the decision can be enforced. Yes, and it is amazing that it is, in all cases, it is enforced. Now, what about Romania and what about the research? So, about the empirical research, we have investigated 13 localities in Romania. There were interviews, collective interviews, and also observing. We have observed 5 trials in 5 different communities. Amazing experience. And very shortly, what I can say is that the findings that we have seen in Romania confirm in practically in all interesting critical details of what the literature writes about the phenomenon. All the things are present. The Krishnitors, the judges, do the things which we read in the literature, sometimes are unimaginable or hard to believe. Effectively, the empirical research confirmed what we learned from the literature. It is interesting that we also discovered new elements which are not included in the literature which we have reached. And these are very interestingly connected to the modernity which is penetrating the Roma communities as well. There are interesting new developments. So practically their instruments are being refined, adapted to the conditions. The new conditions are making more efficient. So the Krishnitor, with whom we had the chance to talk, are sometimes extremely well prepared. They have knowledge of constitutional elements. They have knowledge of modern psychology. Convincing the community is a key element of the whole procedure, so that is really critical. So these are the things, again, without the possibility to go into the details, which have been new things identified in Romania in addition to what we learned from the literature review. Now, there is a discussion. Is that an NTA or not? Yes, if we take as a starting point of the discussion the definition of Rus Lepidot, yes, who says that it has to be an institution established by the minority, yes, which has the role of doing the things, and then it is needed the authorization of the state in order to make it possible that the decisions issued by the institution are binding, yes. Of course, the first part exists, the second part does not exist. Okay, then we might ask the question, how can we explain the fact that this lawmaking system, is there and is enduring since long and extremely efficient and competing efficiently with official law or state law? Yes, and I would like to suggest as a conclusion 2 possible answers to these dilemmas. The one is that there was a similar dilemma regarding the autonomy of the state. Michael Mann, yes, the famous socialist of the state, asked himself where the autonomy of the state comes from. And his conclusion was that the autonomy of the state, it is not granted by anybody. Yes, it is. We cannot say that the autonomy of the state is granted by somebody. It comes from somewhere. And it is said that it comes from the usefulness of territorial concentration of power. Okay, I think that there is a similar possible answer. We know that the Roma communities have undergone a different path of development. They have avoided the territorial concentration. They have lived on the margins of societies. Yes? And we could say that this system of lawmaking became so resilient and effective because it proved its effectiveness in the particular conditions in which the Roma lived. Okay. Regarding why it is so enduring, there is another line of argument I don't have time to go into. Of course, Roma people are marginalized, they are discriminated, they are labeled, and I think there is an evidence, or more or less evidence in the literature, that if communities do not see their values and procedures reflected by state institutions, have incentives to keep their words separate from the state institution. I think that is something which we can. Okay, so what we would like to say that if these arguments are sustainable and if this example can be considered, then we can say that recognition and state authorization might not always be important in the case of NTA. The strong commitment of a community to the objectives of autonomy can supplement authorization and sometimes make even more effective an arrangement than state authorization by itself. And if these things are again sustainable, then the gap between NTA theory and the empirical world, which, as I've said, leaves in the blind spot a lot of cases which are not discussed in NTA theory, could be narrowed. The final statement, just building on something said earlier by Francesco, that I think that if those things, again, pass the test of criticism, then probably that within this distinction between public NTA and private NTA, there might be a new category, which could be, in the private NTA, there could be a category of legally recognized cases of NTA, of private NTA, in a category of non-legally recognized cases of NTA.
Thank you very much. I think I'm going to allow only one question, if you don't mind, Levente, because people can speak to Levente over the coffee. So you had your arm first.
I had my arm first.
Yeah, so you get the only question, the rest in the coffee break.
Okay, thank you. Thank you. It's a really challenging question. Whether customs and cultural traditions could be perceived as NTAs. Now, I will pose one potential problem and then ask a question. In my experience, and I did some pro bono work with Roma, I've never encountered Chris, but I encountered something that are very long practices, like juvenile marriage, you know, and high dropout from schools. Now, if we go and say, let's accept customs and cultural traditions as NTA, you know, for example, Chris passes the test of you know, being a affirmative legal practice or paralegal practice for centuries. But should we embrace those other forms which, you know, clearly do infringe with the common perceptions of what should be beneficial for people? And so this is just a comment, but the real question is, so, okay, let's assume this is right. What do we do? Shouldn't we then recognize them officially? Why keeping them unofficial? You know, like, then we should do something about it. Okay, sorry.
Levente?
Thank you very much. I was expecting this question. So my discussion avoids the human rights implication of the issue. Yes, I know the problem from the perspective of normative political philosophy. I know that it is a very, very serious problem. Is there a justification to protect with the instruments of minority rights illiberal practices or not? Yes, and we know that the answer is not easy to this issue. So what I would like to say is that all what I said should not be understood as an advocacy. Maybe I was very emphatic because it is a surprise. It's a very fascinating type of reality which very, very few people know about. So I accept that I was very sort of kept. How do you say that? So I'm fascinated by this topic, but by no means try to be advocating for it, neither from the perspective of human rights, neither from the perspective of official recognition. I'm saying that this is a reality which is ignored by theory, and it is a pity, because understanding the reality and adding to what we regularly know about Roma could deepen our understanding of their problems and could make our attempts to find solutions for their integration more effective. Yes, if you don't know things of that kind about them, I think that it is little chance for have a good solution for what they need in order to have a fair integration in the society. Now, the fact is that I didn't go into the details. A few things I mentioned in the paper that in Romania, there are very, very interesting cases when local authorities effectively build on that. They not only tolerate, but they encourage this thing. Because exactly as I mentioned in these letters of recommendation, what kind of explanation may be behind them, the local authorities, the police effectively says that it is more effective to leave the Roma community resolve their problems inside than going with force by police force in the community, which could generate a lot of other problems. Yes? Now, I have to stop here. I cannot go into further details. What I would like just to add is that to the question, what is the solution to the Roma communities? Because that is probably one of the background of your question. I believe that there is a very, very biased dominant view in the dominant societies, which is focusing on assimilating them. So by integration, we understand assimilating Roma. Now, I think that it is not fair. Sometimes it is even impossible. And it is more important to consider a solution depending on the very varying situation on a scale which has at these two extremes assimilation on one side and empowerment on the other side. So I think that I'm not advocating for anything, but I think that in order to be more effective, more knowledge about what their word is needed.